Ma'am, are we ready to start the session?
Aryan, I will write it in the chat box once you have to start, then you can take the permission. I will give you
Good.
the
Good evening, ma'am. Are we ready to start the session? Hello.
Yes, we are good to go.
Okay. So, I'll be starting the session now. Good evening, everyone. I am Aryan Gupta, the host for today's session. I, on the behalf of the whole Jus Corpus team, welcome you all in the today's session on understanding preamble to the Indian Constitution with special focus on access to justice. Before we delve into today's session, let me provide you all a brief introduction of Jus Corpus and the honorable and eminent guest speaker we have among us today. Jus Corpus is a body of legal professionals who have come together to bring various aspects and chains of law under a single umbrella. Jus Corpus, an edtech platform set up in 2020, having the worldwide reach of 600,000 clicks per month on an average basis on our website. The inspiration was derived from the ever growing need of the law students. Jus Corpus has also incorporated an interdisciplinary journal and a multidisciplinary journal as the subsidiaries, named as the Jus Corpus Law Journal and the International Journal of Law Research, Education and Social Sciences. Now, turning our attention to the focal point of today's session, we are privileged to have Dr. Daksha Sharma as our esteemed speaker. Ma'am is presently working as Assistant Dean, Placement and Alumni Relations, Head Center for Constitutional Law Studies or CCLS, Assistant Professor of Law at School of Law, Bennett University, the Times Group, Delhi NCR. She is also appointed as an arbitrator at Prasar Bharati, New Delhi, and is regularly invited to deliver lectures on constitutional law, alternate alternate dispute resolution, international law, human rights law, and law relating to women and children rights. Additionally, she is also invited to deliver lectures about new criminal laws and environmental laws at the Delhi Police Academy, Rajinder Nagar, New Delhi. Institution of Constitutional and Parliamentary Studies (ICPS), an institute under the Lok Sabha Secretariat at New Delhi, and the Indian Institute of Law (ILI) New Delhi. She possesses a 10-year of rich and diversified experience in legal industry and academia. She has co-authored a book on spectrum politics, unveiling the defense, with senior advocate Salman Khurshid, former Minister of External Affairs and Minister of Law and Justice. Also, she has edited a book titled Emerging Constitutionalism Trends and Transformations, which discusses about the various international and national facets of constitutional law. She has assisted Honorable Mr. Justice R.F. Nariman, former Judge of Supreme Court of India, in the project on dissenting judgments of the Indian Supreme Court 1950 to 2016 in 2017. She has also published a patent titled as Translation of Legal Documents in the Official Journal of Patent Office in 2024. As a part of social initiative, she is successfully running the Rising Stars, a community service program in Kailash Hills, East Kailash, New Delhi, with the support of Kailash Hills residents from September 2022, with a special focus on Article 21A of the Indian Constitution, which describes the right to education, thereby supporting the cause of education in the children of the age group 16 to 14 years. She has also been awarded the prestigious 5th Dr. Sarojini Naidu, the Nightingale of India Award for Working Women 2021 by the International Chamber of Media and Entertainment Industries, ICMEI, in association with International Women's Film Forum on September 24th, 2021. Also, she has been awarded with the Global Peace Award 2022 by Admission World Education Platform for making significant positive contributions in the society on September 5th, 2022. She has also been bestowed upon National Corona Warrior 2022 Award by Sampak Kranti, a daily newspaper, for providing pro bono legal aid during the COVID period. She is a lifetime member of All India Law Teachers Congress or AILTC New Delhi, council member at Women India Chambers Commerce and Industry VICCI New Delhi, and faculty advisor at the Sambhav Initiated Gujarat, sponsored by Jus Corpus Law Journal Advisory Board and AD and Alternate Dispute Resolution Hub, New Delhi. She has practiced law from 2017 to 2022, wherein she dwelt with numerous cases in the Supreme Court of India, Delhi High Court, lower courts, tribunals, and commissions situated in the Delhi NCR. So, without further ado, I would like to warmly hand over the floor to ma'am, who will share her valuable insights about the topic.
Thank you, Mr. Aryan, for introducing me in detail. I would like to welcome all the participants in this session. But before that, I would like to congratulate Just Corpus for organizing a wonderful session on a very important topic titled as Understanding Preamble to the Indian Constitution, with special focus on access to justice. So in today's session, we are not only going to discuss about the preambular principles, what they are, what they stand for, but we are also going to understand the core relationship existing between the preambular principles and the concept of access to justice. I request you to please change the slide. So these are the points for our discussion. Number one, I'll be introducing the session to you, and we'll be discussing about the preamble, what is preamble, what it stands for, what is the significance and importance of preamble. And then I'll be discussing about the philosophy of the Indian Constitution. And after that, we will be discussing about the purpose of preamble. So as you can see, I have highlighted 4 important points under the purpose of preamble, which includes enacting clause and preamble serving as the source. Then preamble is providing the rights, is declaring the rights and freedoms. Preamble is declaring the basic nature of the Constitution and the type of government. Moving further, I'll be talking about the principles which are enshrined in the preamble, which are justice, liberty, equality, fraternity, unity, and integrity. And we are going to discuss in detail what these concepts stand for. So those, though these terms are very abstract in nature, but still we'll try to figure out that what is the relevance of justice, what is the relevance of liberty and other principles in the context of preamble, and also as far as their practical application is concerned. And then we'll move on to the last pillar of the lecture, which will be talking about concept of access to justice. So here we will be discussing about international and constitutional reflections on access to justice and free legal aid. And also we will be talking about the new emerging concept of ease of justice. And then finally, we'll try to summarize, conclude the session. And if you have suggestions, you please feel free to discuss about it. And then I'll open the floor for question and answer. So this is the synopsis of today's session. And we are going to move in a very structured way so that if questions are coming to your mind, you can frame the questions systematically, and you can always question after the end of the session. I request Mr. Aryan to please move forward. Thank you. So as the first slide suggests about preamble. Now, what is preamble? Why preamble is important to the Constitution? As we all know that preamble is the introduction and preface to the Constitution. Preamble talks about the important principles and objectives which are enshrined in the Constitution. So therefore, preamble is a significant document which showcases the objectives of the Constitution. It showcases the type of the government, and also it portrays the nature of the Indian Constitution. As far as the text of the preamble is concerned, I have included it in the next slide, but for convenience, I'll read out for you. The text suggests that we, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, liberty, equality, fraternity, and unity and integrity of the nation. So we are going to discuss all these terminologies sequence-wise, and we'll understand that what these terms stand for. After that, coming to the next aspect of significance of preamble. So a couple of times we come across the question that why preamble is important, why we are talking about preamble in this important session. Preamble is important because it tells us about the nature of the government. It talks about the philosophy of the Constitution in brief. It states that the concepts and the principles of the Constitution are important for implementation as well as enforcement. It also declares the fundamental rights of the people and various directives which are lying in Part 4 of the Constitution. So as we know that preambular principles are peculiar to constitutionalism. Now, interestingly, a question must be coming to your mind, what is constitutionalism? So when I'm talking about preamble, it's understandable that preamble is the introduction to the Constitution. It talks about the basics of the Constitution. It talks about the ideals and values of the Constitution. But then I have used the term constitutionalism. What is that? What it stands for? And are preambular principles directly related to constitutionalism? Okay. So first, we would try to answer what is constitutionalism. So constitutionalism means efficiency in the working of constitution. At times, it is possible that a country may have written constitution, but it lacks constitutionalism, which means that constitution is not effectively working in that particular country. And on the other hand, it might be possible that a country may not have written constitution, but it has constitutionalism. So what is this analogy and what it stands for? It means that the aspects of constitution, constitutional law, and constitutionalism go hand in hand. Constitution is the living organic document which describes the rights and duties of the people, which also describes about the nature and quality, which describes about the type of the government. Constitutionalism, on the other hand, showcases the efficacy of the working of the Constitution. And as far as constitutional law is concerned, it is a bigger umbrella which comprises of constitution, related conventions, precedents, and other unsaid conventions. So all these aspects are important to understand preambular principles. Now, after discussing about the importance of preamble, let's talk about the resilient and modernized approach. What is the resilient and modernized approach of the preamble? This approach suggests that preamble forms the bedrock of democracy. Preambular principles are important for having rule of law in place. If rule of law is intact, then we can say that constitutionalism is highly effective in a nation. As far as the implementation of the preambular principles are concerned, we rely on the laws enacted as well as the role of judiciary, the way judges are coming up with the judgments. For example, recently in 2024, we have come across the judgment of Bilkis Banu, wherein we have learned that rule of law is in place. So at times, it becomes necessary to study these principles from practical dimensions. We try to study these principles from theoretical perspective, but it would create wonders if we try to analyze, understand, and interpret these principles from practical perspective and application. I hope we are clear so far and all are on the same page. If yes, then I request Mr. Aryan to please move to the next slide. Thank you. So as you can see here, we have this text of preamble. It states that we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure to its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Now, let's talk about these terms one by one. So I've already introduced what preamble is. I hope we all are clear with the definition and meaning of preamble. After that, text of preamble starts with the word we. Now, what this we signify here? So here we signifies that we, the people of India. It provides for the source of Constitution, that the source and power of the Constitution is we, the people of India. And we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens. So here we need to understand that when we are talking about we, the people of India, essentially the aspects of citizenship automatically are coming into picture. So it is quite clear from the language of the preamble that these preambular principles are majorly for the purpose of Indian citizens. They are catering to Indian citizens. So, of course, Part 3 provides us with certain exceptions wherein non-citizens also have fundamental rights. But when we talk about the language of the preamble to the Indian Constitution, we find that these preambular principles cater to the needs of Indian citizens, because here it is written we, comma, the people of India. And what is resolved by we, the people of India? The people of India have resolved to constitute India into sovereign, socialist, secular, democratic republic. Now, we are going to analyze these terminologies one by one. Now, there is a history attached to it that how socialist and secular aspect have been introduced in the Constitution. So we must be aware that these terminologies, socialist and secular, were introduced by 1976 amendment, that is 40, which is known as 42nd Amendment to the Constitution. It was introduced in the year 1976, and this particular amendment is also known as Mini Constitution of India. So when we talk about these terminologies, sovereign, socialist, secular, democratic republic, they talk about the historical dimensions, the historical aspects. So if we rely on the Constituent Assembly debates, on November 15th, 1948, it was proposed by Professor K.T. Shah that preamble should include only 3 terms with respect to the nature of the Constitution and the type of the government. And these 3 terms were secular, federal, and socialist. After that, the same was opposed by Mr. H.V. Kamath, who stated that the words sovereign, democratic, republic should be inserted instead of the words which were suggested by Professor K.T. Shah. And after that, there was one more suggestion by Mr. Maulana Hasrat Mohani, who was the leader of Indian National Congress and a popular Urdu poet. He stated that the term sovereign independent republic sound much better in the context of preambular principles and the text of preamble. So after this debate, it was analyzed that the best part is to keep the words which were suggested by Professor K.T. Shah, that is, which was suggested by Mr. H.V. Kamath, that is, sovereign, democratic, and republic. So when we see the original preamble and the original constitution, we find the words sovereign, democratic, and republic. Socialist and secular terms were introduced by way of 42nd Amendment Act in the year 1976. And this Amendment Act also has a history, that why it was introduced in 1976. We all know that that was the period which witnessed emergency, internal emergency. And interestingly, at that period of time, the terms socialist and secular were introduced in the preamble. So it's quite interesting to note all these developments, that how the preamble was amended in 1976. After that, let's focus on the terms which are written here, and we'll try to analyze the meaning of these terminologies. First one is justice. Social, economic, and political justice. What is justice? Justice is existence of justness. So wherever there is justness in the society, we can say that justice is delivered. Justice is also about taking the side of right over wrong, supporting the righteous conduct. So therefore, this is a very abstract concept, because the concept of justice would evolve from time to time. What may be considered to be just at the present moment might not be considered to be just in the next moment. So these are very abstract terms which have been included in the preamble. But then if we analyze the practical implications, we would find that because of these terminologies, our laws are well placed. Our laws are highly recognized. I'll be giving examples in some time. Now let's focus about the aspect of liberty. So the preamble includes liberty of thought, expression, belief, faith, and worship. Now, if we focus on this aspect of liberty, I would like to highlight here that there is a difference between liberty and freedom. And it's quite interesting to note that preamble includes the term liberty and does not include the word freedom. Whereas in part 3 of the Constitution, you would find fundamental freedoms from Article 19 to Article 22 of the Constitution. And there you would not find the mention of this term liberty. So there has to be a difference between these two terms, liberty and freedom. So the next question is, are these terms synonyms to each other, or can we use these terms interchangeably? So the answer to this question is that these terms cannot be used interchangeably. The preamble is suggesting to have liberty as a principle and liberty of thought, expression, belief, faith, and worship. But yes, this principle is indicative of the existence of the fundamental right, which is there in Part 3 of the Constitution, especially in the context of fundamental right related to religion, fundamental right to religion, from Article 25 to Article 28. Now, let's focus on the next term, equality. What is equality? And is equality related to the principles mentioned in the Constitution in any of the parts. So to define this term equality, as we all know that equality signifies equality before law, equal treatment before the court of law, and equal protection of laws. So there are two concepts related to equality. One is equality before law, and another one is equal protection of laws. And this equality signifies both positive as well as negative concept. Now, coming to the next term, which is fraternity. Fraternity means common brotherhood. So fraternity assuring the dignity of the individual and the unity and integrity of the nation. Now, these terms, unity and integrity, they were also introduced after a later point of time, and they were not there in the original constitution. In 1976, we found that these terms were introduced, and these terms are equally relevant in the present times also. Then the next words are in our Constituent Assembly. This 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. So one important aspect here is that we need to remember that the adoption and enactment date of the Constitution is different from the enforcement date. So adoption and enactment date is 26th November 1949, and the enforcement date of the Constitution is 26 January 1950. Now coming to the practicality which is associated with the preambular principles. So all these theoretical perspective we have been reading in the constitutional law books. We have been reading in many documents. But what is the practical significance and relevance of the preambular principles? So we need to understand that when we are talking about justice from the context of social, economic, and political dimensions, how this is imported in the legislations. Are these preambular principles really helpful in enactment of legislations, or like are they instrumental in shaping some legislations? I give you examples on this. So if we talk about the aspect of justice, social, economic, and political, can you think of any legislation which is highlighting the principle of justice from all the perspective, that is social, economic, and political justice? For example, we have POSH 2013. We have POXO. We have various welfare legislations. So these legislations are centered around the idea of social justice, maybe economic justice at times. So when we talk about popular labor laws, they signify the aspect of having economic justice in place. If we talk about the latest amendment to the Indian Constitution, that is 106th Amendment, which talks about women reservation in Parliament. We have 73rd and 74th Constitution Amendment Act, which talks about women reservation in Panchayat. So which element of justice is reflected when we have such amendments and we have such enacted laws? So it's very crucial to determine and decide that which legislation is catering to which form and norm of justice. So all the welfare legislations, as what I have given the examples, like POSH, POXO, they are catering to the socio-economic aspect of justice. If we talk about Representation of People's Act 1951, it talks about the political aspect of justice. If we talk about the 73rd, 74th Constitution Amendment Act, or 106th Constitution Amendment Act, it talks about the political aspect of justice along with social and economic aspect. So interestingly, you would find certain legislations which are talking about one dimension of justice, and at the same point of time, you may find other legislations which are talking about the holistic aspect of justice. So I hope that you find it interesting. This is somewhat related to the practical relevance of reading, understanding, and interpreting preambular principles. So whenever we are drafting any legislation, we have to keep in mind the preambular principles. We have to see that whether preambular principles have been taken care of in the legislation and where they find their place and how they can reflect the practices of having rule of law intact. After that, let's talk about the concept of liberty. So as I mentioned that the two terms liberty and freedom cannot be used interchangeably because these two terms are different from each other. As far as freedom is concerned, I hope that you must be aware that no fundamental right, for that matter, no fundamental freedom enshrined in the Indian Constitution is absolute in nature. Fundamental rights are always coupled with the reasonable restriction. So therefore, there is a difference between liberty and freedom. Liberty, we can say that it provides for unrestricted right of expression, thought, belief, faith, and worship. Whereas when we talk about freedom, there has to be certain restrictions. The best example is Article 19 of the Constitution, fundamental freedom of speech and expression, fundamental freedom to move freely and to reside and settle in any part of the country, to form association, to assemble peacefully and without arms, to practice any profession or to carry on any trade, occupation, or business. So these freedoms are mentioned in the Indian Constitution, but they are not absolute in nature because they are always coupled with the reasonable restrictions. Now talking about the next part, that is fraternity and unity and integrity of the nation. I'll cover equality separately, but before that, I would like to mention about fraternity and unity and integrity of the nation. So when we talk about fraternity, we need to understand that how these preambular principles of fraternity, unity, and integrity are reflected in the legislations. So these principles have to be understood and interpreted from the plight of legislative drafting. So, there are laws which talk about the aspect of fraternity. To give you a bigger picture, we have criminal laws, and all these criminal laws, if we see the crux, if we see the goal is to maintain peace, is to provide security to the citizens and non-citizens in some cases. So therefore, the concept of fraternity is well reflected in the preambular principles and in the legislations which are enacted. And then if we talk about unity and integrity of the nation, so we find this particular principle in the Constitution itself. When we talk about Part 1 of the Indian Constitution from Article 1 to Article 4, we find that the principles of unity and integrity have been discussed. So Article 1 states that how India should be addressed. India is the name of the nation, and at the same point of time we can use Bharat also. So two names have been mentioned under Article 1. The title itself suggests union and its territory. Also, these articles have not to be read in isolation. These articles have to be read with the schedules attached to these particular articles, like the relevant schedules are Schedule 1 and Schedule 4 of the Indian Constitution. So as we go deep in these principles, we realize that these principles are not only for reading and for understanding, but these principles also stand for application and interpretation at times. So in many of the cases, we find that judges are using preambular principles very often to come up with the judgments based on rule of law. If you take example of basic structure of the Constitution, we know that the debate itself started in 1951. If we focus in the earlier time, 1950. So from 1950 itself, the debate started. And it got settled with Keshwan and Bharati versus State of Kerala, 1973. But still, we find that the concept is ever-changing in nature, and more principles are included under the doctrine of basic structure of the Constitution. So these preambular principles do form the part of basic structure of the Indian Constitution. And as we know that there is a lot of importance given to the doctrine of basic structure. If we do not have the basic structure of the Constitution, the entire edifice of the Constitution will shake. So it would be a very traumatic situation for the working of the Indian Constitution. So therefore, preambular principles are extremely important for the working of the doctrine of basic structure as well. Now, interestingly, you would be wondering that what is included in basic structure of the Constitution. So we have getting of cases ranging from Keshwanand Bharati, 1973, to the NJAC case, and to the recent one that is Bilkis Banu on rule of law. So all these cases highlight the importance of having basic structure of the Constitution. So in Keshwanand Bharati, very many features of the preamble have been classified as basic structure of the Indian Constitution. And then we find we have cases like Maneka Gandhi versus Union of India 1978 and Minerva Mills versus Union of India 1980. We have Vaman Rao's case in 1982. And if we move to L. Chandrakumar's case in 1997, we find that again and again, the basic structure doctrine is highlighted, especially in the context of secularism also. We must not forget the landmark judgment, which is S.R. Bommai versus Union of India 1994, which highlights the importance of having basic structure of the Constitution, and it declares that secularism is the basic structure of the Constitution. Then moving forward, in 2007, we had the famous judgment of I.R. Kolo. So this is also a very important judgment, I.R. Kolo versus State of Tamil Nadu, 2007. And then we had another remarkable judgment of NJAC, wherein independence of judiciary was highlighted as the basic structure of the Indian Constitution. So the point which I'm trying to bring home here is that these preambular principles have to be understood from the theoretical as well as practical perspective, and the practical application can be in legislative drafting, in writing the judgments, in arguing the cases. So these preambular principles form the basis of any constitutional law case, or for that matter, any case which has to be argued, because these concepts are quite close to the working of the Indian Constitution, and these principles must be kept in mind. So I hope that we all are clear with these aspects of the preamble. My major focus was on the practical application of the preambular principles, because I find that this is missing in many of the textbooks. So I thought that, this is the relevant platform wherein we can discuss about the practical significance of these preambular principles. So I hope the lecture is interesting for all of you, and you are not finding it burdensome. I request Mr. Aryan to please move to the next slide. Okay. So as you can see here, the next slide reflects the name of the courtroom genius, senior advocate Nani Palkhiwala. So late Nani Palkhiwala once stated, "Remember, the Constitution was meant to constitute the nation. The Constitution was meant to impart such a momentum to the living principles of the rule of law that democracy and civil liberty may survive in India beyond our own times, and in the days when our place will know us no more. We, the people of India, adopted, enacted, and gave to ourselves the Constitution. And therefore, we, the people, are also its only keepers. So I found this quote very interesting. That's why I've included this quote in this presentation. So here, late Nani Palkiwala, senior advocate, the courtroom genius, is trying to state that preambular principles form the bedrock of democracy and rule of law. We must not ignore the preambular principles, and they are equally important for the working of the Indian Constitution. I request Mr. Aryan to please change the slide. Now let's talk about the significance of preamble quickly. So I hope that by now you have understood the text of the preamble, the terminologies which are used in the preamble. So let's discuss on the significant aspects of preamble. What is the significance of preamble? What is the importance of preamble? And why preamble is relevant in the contemporary times? So as you can see here, the first point relates to that the preamble reflects the source of the Constitution. And what is the source of the Constitution? The source of the Constitution is we, the people of India. Secondly, preamble highlights the nature of the government, the type of government. It also highlights the nature of the Constitution. And how it is highlighted in the preamble, we have seen that it is sovereign, socialist, secular, democratic, republic. And we have also understood and analyzed the historical insights which we have come across in Constituent Assembly debates in 1948-49. So after this, preamble is important because it encompasses the philosophy of the Indian Constitution. So preamble is the preface of the Constitution. Constitution is a compact contract between the state and we the people. So therefore, certainly preambular principles and preamble itself is extremely significant and important. Then next, it discusses about the rights and liberties. As we have seen while reading the text of the preamble, that preamble showcases various aspects of fundamental rights, as it was talking about equality of status and opportunity. So when we talk about equality of status and opportunity, it is directly indicative of the fundamental right, which is mentioned in Part 3 of the Indian Constitution, right to equality from Article 14 to Article 18. And what is provided there? It states that all persons are equal before law, and there shall be equal protection of laws. So Article 14 is a general article as far as the concept of equality is concerned, because it talks about persons. And when we use the term person, it means both citizen as well as non-citizens. Foreign nationals are also included under persons. Persons include all: male, female, third gender, LGBTQIA, as well as the corporate entities. They are also included as persons. So there is a wide dimension of the term used person under Article 14 of the Indian Constitution. But at the same point of time, Article 15 to 18 are applicable only to the citizens. So coming back to the preambular principles, preamble necessarily discusses about the rights and liberties of the people, and the same principles are found in Part 3 of the Indian Constitution also, which commences from Article 12 to Article 35. And lastly, preamble is important because it contains enacting clause. If you remember, it is mentioned in the last lines that we do hereby adopt, enact, and give to ourselves. So therefore, the enacting clause is found in the preamble. So I hope that we all are clear with the concept of preamble, preambular principles, doctrine of basic structure, and what is the significance of preamble. Now I request Mr. Aryan to please change the slide. Okay. So the preamble serves two important principles. Please click the button. Okay. As you can see here, two important purposes are served by the preamble. First is that it indicates the source, and second one is that it states the objectives. When we talk about the source, we have already understood that the source is we, the people of India. So here, the concept of we, the people of India, is quite clear that only citizens are included. Non-citizens are not included as far as the language and the text of preamble is concerned. So it is serving two important purposes for the fact that first, it is providing the source of the Indian Constitution. And secondly, it states the objectives. It states the goals of the Constitution. And the goal of the Constitution is to have justice, liberty, equality, fraternity, unity, and integrity. So this is also known as the philosophy of the Indian Constitution, which is highlighted by the preamble. I request Mr. Aryan to please change the slide. Okay. So this already we have talked about. According to preamble, India is sovereign, socialist, secular, democratic republic. By sovereign, we mean that there is no external control over our internal affairs, and there is no external subjugation over our government. So we are completely free, we are independent. And just because we are the member of Commonwealth of Nation, it does not mean that we are not sovereign in nature. That membership is for the fact that we were once ruled by Britishers. So therefore, we have not left the membership of Commonwealth of Nations, but that is not affecting our sovereign status at all. So by sovereign means that we are independent, we are completely autonomous, and there is no external control over our government, and there is no subjugation of any sort. Now, talking about the term socialist. Socialist, it means that the control is with the government. So in India, is what our former Prime Minister stated. First Prime Minister of India, Pandit Jawaharlal Nehru ji, stated that in India, we do not have socialism. We have democratic socialism, wherein democracy is wedded with socialism. So these terminologies, as stated, were added by 42nd Amendment to the Constitution in the year 1976. And now we see that the pure form of socialism is not existing. For example, practically, if you see, we have various PPP models, public-private partnership models. So that showcases the fact that, pure socialism is not existing. Ours is a mixed economy. We are not pure socialist in nature. We are not pure capitalist in nature. Ours is a mixed economy, and we are moving with the progressive times. Now coming to the next term, secular. Secular means that the state shall not have any official religion of its own. And secularism does not mean that we are not following any religion. It means that we are respecting all the religions, but the state shall not have any official religion of its own. And to reiterate, in 1994, in the case of S.R. Bommai versus Union of India, secularism was declared, was held to be the basic structure of the Indian Constitution. Now, moving forward with the next point, that is democratic. We are democratic in nature, and ours is a representative as well as parliamentary form of democracy. So by representative, we means that people are choosing their representatives, and those representatives are given the responsibility of enacting the legislation. And then lastly, we talk about republic. Republic means absence of monarchy. There is no control of the king. Source of authority is the people of India, and we have an elected president as the head of our state. I request Mr. Rajan to please change the slide. Now, I think this is the most fundamental part of the session. What is the purpose of preamble? Preamble contains enacting clause. Preamble declares the rights and freedom of the people of India. It declares the basic type of government, and it provides the source of the Constitution. So the goals of the Constitution can be found in the preamble and preambular principles. I request you to please change the slide. So though we have discussed Ketenov cases, but still from this topic point of view, from this perspective, I would like to highlight two important cases. One is in the matter of Berubari Union and Exchange of Enclaves, AIR 1960, wherein it was held that preamble does not form the part of the Constitution. And the famous case of Keshwanand Bharati, 1973, wherein it was held that preamble to the Constitution is of extreme importance, and it is the part of the Constitution, and that the Constitution should be read and interpreted in the light of the grand and noble vision expressed in the preamble. I request you to please change the slide. So these are the principles which are enshrined in the preamble: justice, liberty, equality, fraternity, unity, and integrity of the nation. I hope you all are clear with this. Please change the slide. Now, coming to the next aspect of access to justice, because our topic is understanding the preamble to the Constitution with special focus on the concept of access to justice. Now, what is this access to justice? Access to justice means accessibility provided to the citizens to have justice. So I've tried to simplify this concept, and this concept can very well be associated, can very well be related with the directives of the Indian Constitution. Under Part 4 of the Indian Constitution, we find that DPSPs suggest the state to strengthen the aspects of access to justice. We have Article 39A, pro bono services, free legal aid. These are related to the concept of access to justice. Nowadays, we are talking about ease of justice also. We are talking about door-to-door delivery of justice. So in the light of contemporary reflections, contemporary developments happening in the justice delivering mechanism, like we have ODRs coming to place, online dispute resolution. We have hybrid mode of justice delivery system, which is exercised at time. We are following the system of hybrid courts. We have followed it during COVID, and now also, depending on the facts and circumstances, sometimes it is promoted by the court. So when we are following this hybrid system, we realize that we are moving towards ease of justice. And this concept of ease of justice provides for quality justice. It provides for justice delivered in time, justice delivered in the reasonable time. And it also provides for door-to-door delivery of justice. And I'm quite certain that in the present times, when AI is in place and AI is becoming popular, this dream is not far to turn into reality. So the concept of excess of justice is intact under Part 4 of the Indian Constitution. Also, access to justice is well covered under Part 3 of the Indian Constitution. Access to justice is a fundamental right. It is covered well under Article 21 of the Constitution, which talks about right to life and liberty. So we have very many international law reflections and constitutional reflections on this concept of access to justice. So we have declarations like UDHR, Universal Declaration of Human Rights, 1948. It talks about various aspects of access to justice. Then also we have ICCPR 1966. It is touching on the dimensions of having access to justice. Then various other conventions, like if you just see CEDAW, if you see CRC 1989 Child Rights Convention, you would find that the aspects of access to justice are well covered therein. So it's a very interesting concept, and I would like to highlight here that this particular concept of access to justice is directly related to the preambular principles, because preambular principles are also highlighting the need to have justice, and justice of all kind, justice having holistic dimension, that is social, political, and economic justice. So jurists once talked about having distributive justice, but the kind of justice which we are talking with the modernized time is the holistic justice, which includes access to justice and ease of justice. And this can certainly be achieved with the help of preambular principles only. So there is complete interrelationship between access to justice and preambular principles. I request Mr. Adin to please change the slide. Okay, so now it's the time to recap the points which we have studied. We have studied about the preamble, what preamble stands for. We have also discussed about constitution, constitutional law, and constitutionalism. We have talked about the philosophy of the constitution, which is lying in the preamble itself. We have talked about the purpose and principles of preamble. And lastly, we have highlighted the aspect of access to justice from international and national point of view. And also, we have tried to analyze the concept of access to justice with the new evolving concept of ease of justice. So to conclude, I would like to state that preamble is an extremely important document which showcases the vision, mission, and passion of the Indian Constitution. The need of the hour is to reawaken our interest in the preambular principles so as to apply all these principles practically in all the dimensions, and so as to secure the principles and their evolution in the right sense. We must not read preamble theoretically. We must try to read, understand, and interpret preamble and associated preambular principles in theory as well as in practical sense, and we must try to employ these principles wherever and whenever possible. So with this, I would like to conclude my lecture. I hope that it would be of some use to you. And I've already shared this PPT with Just Corpus. So I request Just Corpus to please share this with the attendees and the enthusiastic participants so that they can benefit with the points I have highlighted. And this can also be used for the purpose of your own notes. So thank you, everyone. It was wonderful speaking on this topic. And again, I would like to thank Just Corpus for having me here. And it's a wonderful opportunity, and it was an amazing experience. Now, the floor is open for Q&A. Next slide. Yeah. So quickly, I'll take 3 to 4 questions.
Yeah. Thank you, ma'am, for such a insightful session. Now, based on the questions that we have received in the comments, I shall tell you the most commonly asked questions, and if possible, you please enlighten us regarding those topics.
Yes.
So, the first question that we received is, how does the principle of access to justice, articulated in the preamble, influence the legal and judicial framework of India in the modern day context?
Okay. It's a very interesting question that where do we find the principle of access to justice in the preamble? Because we have learned that preamble is only talking about the principle of justice, liberty, equality, fraternity, unity, and integrity. So if we try to relate these principles enshrined in the preamble with part 3 and part 4, we would understand that these principles are forming the part of access to justice, and they are useful for understanding the justice delivering mechanism, and these principles are ultimately helpful for achieving the ends and means of justice. So though directly there is no term used in the preamble like any such term like access to justice, but if we interpret preamble in the light of fundamental rights and directive principles, we do find that these principles are directly related to the aspect of free legal aid and to secure justice to those who are needing it the most. I hope I'm able to answer this query. It was an interesting question.
Thank you, ma'am, for your answer about that question. The second question that we have is like how the constitution was amended the preamble was amended in the 42nd amendment. Is there a possibility that the preamble can be amended once again?
Okay, so again, it's a very tricky question, especially in the light of changing political scenario. I was talking about the basic structure doctrine, and under the basic structure of the Constitution, preamble is also a part. So therefore, the doctrine suggests that the basic features of the Constitution cannot be touched upon. And therefore, if we try to analyze this, then as per the various judgments, basic features cannot be altered and cannot be disturbed. And preamble is the part of the basic structure, and it is the basic feature of the Constitution.
Thank you, ma'am. The last question that we have for today is, in what ways are recent judicial reforms addressing the preamble's promise of access to justice for the marginalized communities in our country?
All right. So again, this is a very interesting question. As far as the preambular principles are concerned, we have understood that they are talking about the principles of justice, and justice is mentioned in a very holistic and broader manner. We are not focusing on the narrower aspect of justice. So when we talk about justice, it is social, economic, and political justice. So which means that justice of all kind is included in the preamble itself. So if we are talking about the marginalized community, then certainly these principles become very important. And as we know that these principles are also directly proportionate to the rule of law and a basic structure of the Indian Constitution. So, in Ketenov cases, we find that these principles are interpreted and employed by the courts. I hope I have answered this query.
Yes, ma'am. The questions were beautifully answered, and we extend a vote of thanks to you for providing us with such an insightful session and for providing us with all the answers to our queries. So, in closing, ma'am, we extend a heartfelt thanks to you for accepting our invitation and delivering such an informative session. We trust that the audience found it both interesting and knowledgeable. So once again, ma'am, we thank you and we eagerly anticipate the opportunity to host you once again. Thank you.
Thank you so much. Special thanks to the participants who are attending this session because it gives the confidence that there are law enthusiasts who are quite interested in the Constitution. And again, it signals the need to have more and more awareness of these topics. So I would like to thank our fantastic audience who have come up with brainstorming questions at the end of the session. So I was very happy to receive all these questions. I'm also thankful to Just Corpus for having me here, and I would like to congratulate and give my best wishes for your organization. You are doing a wonderful job, and keep doing good work. Thank you. Thank you, everyone. Bye. Take care. Good night.